This isn't speculation, it's not a proposal, and it's not something that might happen someday. Just a few hours ago, the White House signed a brand new immigration law into effect, and almost no one is talking about what it actually does. If you have a green card, if you're here on an H1B visa, or if you're protected under DACA, this law applies to you right now. Not next year, not when you renew, right now. Here's what makes this truly urgent. The first wave of consequences kicks in before January 30th. That date isn't symbolic. It's written directly into the law as a trigger point. After that, certain protections start to quietly fall away, new obligations come online, and people who believe they're completely safe could find themselves flagged without any warning. Some immigrants are going to move through this transition with no issues at all. Others are going to be stunned to learn they're suddenly under review, not because they broke a law, but because they didn't realize the rules had changed. In the next few minutes, I'm going to walk you through exactly what was signed, who is most exposed, and what you need to do before January 30th to protect your status. And I want to be absolutely clear, this isn't about fear, it's about facts. Everything I'm about to explain comes straight from the actual legislation and the official guidance released today by the agencies that will enforce it. No rumors, no hype, just what's written, how it works, and why ignoring it could be the most dangerous mistake you make this year. I'm Sophia. I track verified immigration changes from places like USCIS and the Department of Homeland Security. When something this significant lands, timing matters more than opinions. Immigration law doesn't usually flip overnight, but when it does, the people who move early tend to stay protected. The people who don't often find out too late. My goal is simple: give you clear, accurate information so you can make smart decisions for yourself and your family without panic and without confusion. To see why this law is causing so much concern, you have to understand how different it is from most of what came before it. In recent years, a lot of immigration changes came through. Executive orders, policy memos, temporary guidelines. Those could be paused in court, revised quietly, or reversed by the next administration. This is not that. What just got signed is full legislation, passed by Congress and written into federal statute. That matters more than most people realize. It means these rules are not optional, they're not test policies, and they're not limited to future applicants. One of the most important, least discussed features of this law is that it applies retroactively. That means it doesn't only affect people who apply for a green card next year, people filing brand new H1B petitions, people applying for DACA for the first time. It applies to people who already have those statuses today. The rules you followed years ago to get where you are no longer the only ones that count. There are new compliance expectations now, and the government is no longer waiting until something looks wrong before it starts checking. This law shifts the entire system from saktin, passive oversight, to active verification. Instead of primarily reacting to problems, the system now goes looking for them. That's why even people who believe they've done everything perfectly still need to pay attention. The law does not assume you are out of compliance, but it does require you to be able to prove that you're not. That one shift, proof instead of assumption, is what's catching so many people off guard. Let's slow this down and put the law into plain language. Its official name is the Immigration Status Verification and Accountability Act of 2025. It's built around one core idea: continuous accountability. The federal government now has the technical ability to track immigration-related data in something close to real time. This law creates a unified digital system that links immigration records, employment data, travel history, tax compliance into a single verification framework. The law is split into 4 main sections: one aimed at permanent residents, your green card holders, one focused on acute employment-based visas, including H1B, one addressing humanitarian protections like DACA, and one specifying enforcement timelines and penalties for non-compliance. Here's what it does not do. It does not instantly cancel anyone's status. It does not set up mass automatic removals. What it does instead is introduce checkpoints at specific intervals and under certain conditions. At those checkpoints, individuals have to confirm their status is still valid and they are meeting all ongoing requirements that come with that status. If everything lines up, nothing changes. Life continues as usual. If something is missing, out of date, or inconsistent, if there are gaps that don't make sense, the system flags the case for review. Not immediate punishment. Review. That distinction is important. The law isn't written to hunt down people who are genuinely living their lives here, following the rules, paying taxes, and building families. It is written to surface inconsistencies, neglect, quiet lapses where someone may have drifted out of compliance without realizing it. And that's where January 30th becomes critical, because that is when the documentation expectations begin to count. From January 30 onward, I didn't know is no longer going to be accepted as a shield. The law assumes awareness. The responsibility shifts squarely onto you to be ready. Who exactly is affected? Short answer: almost everyone who is currently inside the U.S. immigration system. To see the risk clearly, it helps to look at three main groups facing the most immediate impact. 1. Green card holders, lawful permanent residents. 2. H1B visa holders, and other employment-based non-immigrants. 3. DACA recipients. For all three, the biggest danger is the same, assuming this doesn't really apply to me because you've never had a problem before. You've renewed on time. You've traveled without trouble. You've always paid your taxes. You've stayed out of legal issues. That assumption, I've been fine so far, so I'll be fine now, is where the risk lives. This law doesn't wait for a mistake, it checks for one. And if you're not ready when that check comes, a small oversight can easily snowball into months of stress, delayed work authorization, or worse. If this affects you or someone in your life, make sure you stay plugged in. Immigration changes like this don't always come with big, loud warnings. Missing a single detail can cost a lot. Let's start with the largest and most confused group right now: green card holders. For permanent residents, the change is not obvious at first glance, but it's deep. Under the old approach, once you got your green card, your ongoing duties were fairly simple. Keep the U.S. as your main home. Avoid serious criminal issues. Report address changes within the deadline. Renew your physical card when required. Apart from those, the system largely ran on trust. Unless a specific event triggered a review, like a long trip abroad or an arrest, the government generally did not check in on you. That honor-based era is effectively over. The new law places every green card holder into what it calls an ongoing status verification framework. Instead of only examining your case when something looks wrong, your status will now be periodically confirmed on a routine schedule. By the statute, every permanent resident is required to complete a formal verification process at set intervals. This is mandatory, tied directly to maintaining your status, not something you can ignore without consequences. Here's how it looks in practice. On a regular schedule, currently set at every 18 months, you'll receive a notice telling you to verify key details about your life in the U.S. That notice may come by mail, through a new secure USCIS online portal, or both. Once the notice goes out, a timer starts. You'll be asked to confirm your current physical address, your employment or financial situation, your travel outside the U.S. during that period, your continued intent to live here as a permanent resident. For people who are prepared, the process itself is meant to be straightforward, maybe 20 minutes online. Preparation is the entire point. If what you submit doesn't match what the government's other databases show, if there are unexplained trips, missing years of tax returns, different addresses, or inconsistent employment, your case doesn't just vanish, it escalates, not to automatic removal, but to administrative review. That's where documentation matters. That's where organization matters. That's where people who've treated immigration as set it and forget it suddenly find themselves under scrutiny they never expected. Here's a realistic example. Take someone named David. He got his green card years ago through his U.S. employer. He owns a home, his kids go to school here, he files U.S. tax returns every year. On paper, he looks like the definition of a stable, permanent resident. In 2023, David's employer sends him on an 8-month assignment to their London office. His wife and kids stay here. His mortgage and bills are paid from his U.S. accounts. His life is clearly still centered in America. Under the old system, that probably would never have raised an eyebrow. Maybe a question at the border. That's it. Under the new law, when David does his 18-month verification and the system sees a continuous 8-month absence, his case is automatically flagged. Not because he did something wrong, but because he crossed a travel threshold designed to trigger a closer look. Now, he has to prove that he did not abandon his residency. That might mean a letter from his employer showing the assignment was temporary, evidence his family remained here, proof of continuing ties like a mortgage, bank statements, school attendance. If David has those documents organized, the review can be resolved quickly. If he doesn't, it can drag on. The law doesn't punish David for traveling. It makes him justify how that travel fits with permanent residence. So, what actually triggers these deeper reviews? According to the initial guidance released alongside the bill, several events push a case into further examination. A single trip abroad lasting more than 180 days in total time spent outside the U.S. exceeding 240 days in any rolling 12-month period. Failing to file U.S. tax returns for any year since getting a green card, big address mismatches between USCIS records and other government databases, long gaps in employment with no documentation of how you supported yourself, maintaining substantial property, businesses, or assets abroad that could indicate your primary home is not clearly in the U.S. None of these automatically take away your green card, but each one requires explanation. And under this law, explanation means evidence, documents, not just your word. This is usually where anxiety spikes, so let me underline something. A flag is not the same thing as a revocation, it's a request for proof. The system isn't designed to chase out people with real, established lives here. It's designed to narrow down cases where permanent residence may be more of a convenience than a commitment. If your life is truly here and you can show that on paper, this law is survivable. What it takes away is ambiguity and silence. The old benefit of the doubt has been replaced with show me. Now, about the January 30th timeline, the full digital verification platform isn't expected to be completely live until later in the year. That's true, but the law says the documentation expectations begin January 30th. From that day on, you're expected to be maintaining your records as if a verification request could appear at any time. In other words, January 30 is the beginning of your obligation to be ready, not the day enforcement starts knocking. So if you have a green card, there are concrete steps you should take before that date. Make sure your address with USCIS is current. Don't assume your driver's license update changed immigration records. It didn't. Gather copies of every U.S. tax return you filed since you became a resident. If there are gaps, talk to a tax professional now, not later. Build a simple travel log. Dates you left and re-entered the U.S., where you went, and why. Accuracy matters more than fancy formatting. Collect proof that your main home is here. Leases, mortgage statements, rental agreements, utility bills, car registrations, insurance policies, employment letters, school enrollment for kids, joint bank accounts. Keep documents that show your close family in the U.S. Marriage certificates, birth certificates for children, their green cards, or citizenship proofs. This doesn't change your status. It simply puts you in the best possible position when the system asks you to confirm that status. The people who struggle under this new framework usually aren't those who broke rules. They're the ones who didn't realize they'd ever be asked to prove compliance years after the fact. Let's turn to H1B visa holders. Now, because the shift here is just as serious, but it works differently. If you're on H1B, your legal status is tied to your job in a very specific way. Under the old system, your employer had to file initial petitions and extensions, keep certain records internally, abide by wage and job terms. In practice, enforcement was uneven. Many companies were never audited. Job roles changed, locations changed, wage structures changed. Often, as long as nothing triggered an investigation, discrepancies stayed buried. That period is ending. The new law creates a centralized, employment-based visa compliance registry. Every employer who sponsors H1B workers must now file quarterly verification reports, confirming that each foreign worker is still in the job described in their petition. They are at the approved work locations. They are being paid at or above the required wage. Quarterly means 4 times a year, every 3 months. 4 checkpoints instead of 1 at extension time. Under this structure, issues surface early instead of years later. If an employer fails to file reports, files incomplete or inaccurate data, reveals large discrepancies between approved terms and actual work, the employees attached to those petitions are automatically flagged. The law also introduces something analysts are especially focused on, a status contingency provision. This allows for temporary suspension of work authorization if an employer is found to be out of compliance while the government investigates and fixes the problem. That doesn't mean automatic deportation. It doesn't necessarily kill your H1B. But if you're told you must stop working temporarily and your immigration status depends on active employment, even a short interruption can be disruptive. So if you're on H1B, what do? Talk to your HR or legalstatus immigration team. Ask if they are aware of the quarterly reporting requirement and what systems they're putting in place. Review your own paperwork, your I-797 approval, labor condition application, LCA, and job offer. Compare the job title, duties, location, and salary listed there to what you're actually doing now. If your role, salary, or primary work location have materially changed, ask whether an amended petition is needed. Filing an amendment before the registry flags a mismatch is much safer than trying to explain it after. If you're eligible to start a green card process or explore a more stable status, consider not delaying. This law doesn't make H1B unworkable, but it does make blind trust in your employer's compliance much riskier. Now, DACA. There is a lot of confusion and fear here, so let me separate fact from rumor. This law doesn't abolish DACA, automatically cancel current approvals, create a new path to removal for people who are otherwise eligible. The core protections are still there. What the law does do is make the renewal process more document heavy, more frequently checked, less forgiving of timing mistakes. Under the new rules, every DACA renewal now requires enhanced status verification. In simple terms, that means each renewal must be accompanied by updated proof of continuous residence in the U.S., updated proof of school enrollment or employment, a fresh background check, new biometrics, fingerprints, photos every time. Not just the first time, that alone will slow processing, especially during the transition phase. But the most critical change is the renewal window. Until now, you could submit a DACA renewal up to 150 days before your expiration date. That extra room made it easier to handle delays. Now, the law shrinks that window to 120 days. 30 days may not sound like much, but in an already backlogged system, it's significant. And the law is extremely clear. If your DACA status expires, even by up to 1 day, you cannot simply file a late renewal the way you used to. An expired period is treated as a break in protection. And because new initial DACA applications are not being accepted, falling out of status is very hard to fix. That makes timing everything. If your DACA expires anytime in 2025, you need to look at your card or approval notice now. Count back 120 days from that date. Treat that day as your real personal deadline to file. Do not assume the old 150-day practice still applies. It doesn't. The safest habits for DACA recipients under this law: track your expiration date meticulously, Start gathering renewal documents months before you hit your 120-day mark. File as early in that window as the law allows. Build in room for slowdowns you have no control over. This framework doesn't punish people who keep up with the rules, but it offers zero slack for those who miss renewal windows, even if the slip was unintentional. Stepping back, if you look across green cards, H1Bs, and DACA, a pattern emerges. This law marks the end of passive compliance. The system is no longer built on everything is fine unless we hear otherwise. It's shifting to everything is fine, if and when you can show that it is. That doesn't mean the system is out to get you. It means it's structured, and it expects you to be structured too. Organized, proactive people will move through this quietly. People who assume silence means safety will feel ambushed. The real risk right now isn't the written law. It's people who don't realize it exists or how it works until they get a notice asking them to explain something from 2 or 3 years ago. So here's the bottom line. In clear, practical terms, the Immigration Status Verification and Accountability Act of 2025 is law. It's active. January 30 is your preparation deadline, not your start paying attention date. If you have a green card, confirm your address with USCIS, organize your tax returns and travel history, put proof of your home, work, and family ties in one place. Assume you may be asked to prove your story and make it easy for yourself to do that. If you're on H1B, make sure your employer understands their new quarterly reporting duties. Check that your actual job matches what was filed, correct discrepancies early, explore longer-term options if they're available to you. If you're on DACA, treat your expiration date like a hard line. Recalculate your renewal window using 120 days, not 150. File renewals as early as you're allowed. Don't cut it close on timing under any circumstances. Across all of this, remember, the law isn't aimed at ejecting people building genuine lives here. It's aimed at removing uncertainty. That will feel uncomfortable if you've relied on no news is good news in the past. But in this new environment, quiet doesn't mean safe, prepared does. The strongest position you can be in now is not fearful, it's ready. Know your status, know your documents, know your deadlines. Don't assume last year's unwritten rules will save you this year. I'll keep following how USCIS and DHS roll this out and share updates as detailed guidance appears, because when things move this fast, clarity is not a luxury. It's protection. If you know someone with a green card, an H1B, or DACA, make sure they know this is real. It's in motion, and it affects them now. The biggest risk in this moment isn't enforcement. It's not knowing the game has changed until you're already being asked to explain yourself.